Here to weigh in with his legal analysis, Alan Dershowitz, Professor Emeritus at Harvard Law School, author of many books, including the one Get Trump. So, Professor, welcome, and thanks for coming on. We're awaiting jury instructions today, about 40 minutes from now. How crucial will those be for the jurors?
Well, first of all, the prosecution did a terrible, terrible thing, extremely unethical yesterday. They misled the jury. They told the jury that they could convict, find all the elements of the crime without believing Michael Cohen. That's just not true. The only evidence that Donald Trump knew of this at all comes from an uncorroborated conversation with Michael Cohen that could have been corroborated by Alan Weisenberg. But the prosecution didn't call Weisenberg. Then you combine that with the unconstitutional New York rule that the defense goes first and the prosecution gets the last word. Absolutely unconstitutional, because it puts the burden of proof on the defense. How does the defense go first when it doesn't even know what the crimes are that turned the misdemeanor into a felony? They had to wait until they heard it from the prosecution's closing argument, and then they had no chance to rebut. So what we saw yesterday was unethical behavior by the prosecution, unconstitutional behavior by the judge, and the lack of corroboration for the crucial conversation that might criminalize what was otherwise innocent behavior.
Professor, I'm curious to know how time plays a factor when it comes to the jury. They had to listen to closing arguments, obviously from the defense, and then the prosecution took around 11 hours. They were into the evening hours of the night. There were reports of some yawning, some to be very sleepy, some bored at some moments. Does that play well? Remember, the prosecution took the longest time. Does that play well for their case specifically? How does time affect that with the jurors' decisions?
No, I think the prosecution did take too long. If the case is so obvious and so simple, they should have been able to summarize in an hour or two. And now we'll hear the instructions. The instructions will be complex, difficult, incomprehensible, legalese, and the defense, the jurors will have to remember the instructions because they won't get copies of them to take into the jury room. So when you combine these long closing arguments with an incomprehensible instruction, which will obviously be biased against the defendant, it makes the jury's job very hard. But I want to emphasize again how unconstitutional the New York law is, and I would hope the Trump team would challenge it, allowing the prosecution to go last and not giving the defense a chance to rebut, making the defense go first. It conveys to the jury the obvious error that there's some burden on the defense to go forward. If I were a defendant in this case, what I would have done is, Your Honor, I'm sorry, I have no burden. I have nothing to say. I'm going to wait until I hear the prosecution's case, and then I'll respond to it. But you can't make me respond to a case that I haven't heard yet. And that's the way New York law operates. When you combine that with the misleading nature of the prosecution's argument that Cohen essentially was corroborated. He was corroborated on some things. But the crucial conversation, the only evidence, and that's what CNN was essentially saying, the only evidence that Donald Trump had any knowledge of this comes from uncorroborated Cohen conversations. You wouldn't buy a used car from that guy, and you should not convict somebody based on that uncorroborated testimony. But the fact that the defense was forced to go first imposed a burden on them, which the jury will take into the room. And if I had been the defense, I would have put a full-blown picture, a life-size blown-up picture of Alan Weisenberg on the witness stand and say, ladies and gentlemen, why do you have a picture here? You should have had a real person testifying, subject to cross-examination. What did the prosecution hide from you? Why did the prosecution not tell you that? And the crucial question today is, will the judge give a missing witness instruction? The missing witness instruction would say something like this: ladies and gentlemen of the jury, the prosecution could have immunized, called Alan Weisenberg. They didn't do it. You should infer from that had he testified, he would have testified unfavorably to the prosecution and would not have corroborated Cohen's testimony. Will he give that instruction? I doubt it.